Hello, and thank you for joining me for this brief webinar on Seattle's Paid Sick and Safe Time Ordinance. My name is Darius Foster, and I'm the Outreach Manager for the Seattle Office of Labor Standards, and I'll serve as a facilitator for this recorded webinar. The primary objectives for this webinar are to ensure employers are, one, aware of their obligations under the law, and two, understand key amendments and compliance requirements. Before we dive in, it's important to note, this webinar is for informational purposes only and is not for the purpose of providing legal advice, creating an agency decision, or establishing an attorney-client relationship between the Office of Labor Standards and the recipient. Any responses to specific questions are based on the facts as we understand them and are not intended to apply to any other situations. And if you need legal advice, please consult an attorney. Before we get into the nuts and bolts of the Paid Sick and Safe Time Ordinance, I want to take a moment of your time to introduce the Seattle Office of Labor Standards to folks who are not familiar with the office. Back in 2012, the City of Seattle passed its first labor law. Coincidentally, it happened to be the Paid Sick and Safe Time Ordinance. Between 2012 and 15, it passed a total of 4 labor laws. And in 2015, City Council passed legislation creating the Seattle Office of Labor Standards to implement and enforce the city's labor standards. The mission of OLS is grounded in workplace equity. And this is done by advancing labor standards through thoughtful community and business engagement, strategic enforcement, and innovative policy development with a commitment to race and social justice. OLS offers a range of services to help employers to comply with Seattle labor laws. These private and free services include labor standards investigations, outreach and education to workers and businesses, compliance assistance for businesses, and resources and referrals. For direct support, employers can contact us in one of 3 ways: by phone, email, and by submitting a web intake form that's located on our website. Moving right along, it's important to highlight a key provision addressed in most of the labor standards, and that's the notice and posting requirement of the 11/17 Seattle Labor Standard Workplace Poster, created and distributed to employers by OLS. One important note, the poster is revised annually. Employers must ensure they have the most current poster available. Additionally, employers must display the poster in a conspicuous and accessible location where employees work, in English and in the primary languages of the employees at the workplace. Most employers are covered by one or more of the 5 labor standards listed on the current 2020 11/17 workplace poster. However, the smaller 8.5/11 secure scheduling workplace poster only applies to certain employers. Okay, without further delay, let's jump into this training with an immediate update. As a result of COVID-19 on March 16, 2020, Seattle City Council amended this law to expand the uses of paid sick and safe time. These changes became effective on March 18, 2020, and are included in this presentation. Right off the bat, I'll address a few frequently asked questions to help us find our stride, and then we'll expand to cover other key requirements. Some of these questions include some of the following that you see. For example, what is PSST? Which employees are covered by PSST? How much PSST is the employer required to provide? How much PSST can an employee take at one time? And can you as the employer, require an employee to use PSST? Paid sick and safe time is employer paid time off that employees can use. And they can use this time to care for themselves or a family member, to go to the doctor to get medical and preventative care for themselves or a family member. When employees are recommended by public health officials to self-quarantine, when their family member's school or place of care closes, when their place of business has been closed by order of a public official for health-related reasons, and for, in this scenario, when you have businesses of 250 or more full-time equivalent employees worldwide, when their place of business closes for any health or safety reason. Can an employee use PSST if their place of work is closed because of a possible health concern like COVID-19? The answer is yes. Under the following circumstances, employers must allow employees to take PSST if their place of work is closed by the order of a public official for a health-related reason. In the event where you have employers that have 250 or more full-time equivalent employees worldwide, they must allow employees to use PSST if their place of work reduces operations or closes for any health or safety related reason, and it does not have to be ordered or recommended by a public official. Can an employee use PSST if their family member's school or place of care is closed? And the answer is yes. Prior to March 2020 amendments, employees could use PSST when their child's place of care or school was closed due to the order of a public official for a health-related reason. Now, an employee may use PSST if any family member's place of care or school is closed, and the law no longer requires that the closure be for a health-related reason or that a public official order the closure. To clarify some things, who exactly is a public official? Well, a public official is a government employee that is granted the authority to close a place of business or school. And this can include local, state, or federal authorities, or the superintendent or principal of a public school. Can you, as the employer, require an employee to use PSST? The answer is no. Employers cannot require employees to use PSST for an absence that is otherwise covered by the ordinance. Can an employee use PSST for reasons other than that protected by the law? And the answer is yes. An employee can allow the use of PSST for reasons not covered by the law. Does an employee have to find someone to cover the hours that they need to take PSST? The answer is no. An employer cannot require an employee to find someone to cover their PSST hours. What if an employee has used all of their accrued PSST or is a new employee without any accrued leave? Well, an employer is only required to allow an employee to use accrued hours of PSST. In their discretion, employers can provide more pay leave or allow the use of vacation or other accrued leave, but it's not required. Other laws may require an employer to provide employees with leave, including the Family and Medical Leave Act, Washington State Paid Family Medical Leave, and other federal, state, and local disability laws that may exist. As we continue to move right along, let's talk about who's covered by PSST. So this law covers overtime eligible and overtime exempt employees. And these are employees who work within the city limits, regardless of the size or location of the employer. And this includes full-time, part-time, temporary, and also seasonal employees. How much PSST are employers required to provide? Well, an employer's specific obligations depends on their tier size. And to determine tier size, an employer must count the compensated hours of all employees who perform work in Seattle and outside the city. This includes worldwide. The rate of accrual and carryover requirements coincide with the employer's tier size. So for a tier 3 employer, the rate of accrual is 1 hour of paid sick and safe time per 30 hours of work. Here's what you need to know about accrual, use, and carryover. There are no limits on the number of PSST hours an employee can accrue within a calendar year. This is all tied to the number of hours that they work. So the more hours they work, the more PSST they will accrue. There's no limit on the number of PSST hours an employee can use within a calendar year, so long as an employee has unused PSST hours available. And employees must permit employees to carry over unused PSST to the next year. There is a limit on the number of unused PSST hours an employee can carry over to the next calendar year, and that is contingent on the employer's tier size. This leads us to an important question. How much PSST can an employee take at one time? And so the answer is an employee can use all of the hours, assuming they've accrued time, for an authorized purpose in the increments as small as the smallest amount of time that an employer tracks work time, but no longer than an hour. So in this situation, if for whatever reason an employee needed to be out for 2 months, and they had hours, unused time to cover that time period, they can use all of that time, assuming that it's for an authorized reason covered under the law. We'll spend the remainder of this webinar expanding a little bit more into the compliance requirements associated with paid sick and safe time. Requesting use of PSST. Employees are not required to specifically ask for paid sick and safe time or reference the ordinance when requesting PSST. Instead, employees simply must state their need for an absence for a reason covered by the ordinance. And it can be as simple as, I am sick and need to miss my shift today, or I need to use my PSST. Employees also can say, I need paid sick leave for safe time absences and do not need to identify the reason as a safe time reason. When requesting the use of PSST, employees are required to comply with an employer's notice policy for absences and or leave requests, provided that those policies do not interfere with the purpose of PSST. For leave that is foreseeable, a written request should be provided at least 10 days ahead of time, or as early as possible, unless the employer's customary notice policy requires less advance notice. In instances where you have an unforeseeable event, the employee must provide notice as soon as it's available, and it must generally comply with an employer's customary notice policy and or call-in procedures. This leads up to a good question. Can an employer deny PSST and or otherwise discipline an employee for failure to comply with an appropriate advance notice provision? And the answer is yes. An employer may require employees to comply with the employer's notification policies as long as such policies do not interfere with an employee's lawful use of paid sick leave. However, an employee could be disciplined for failure to comply with the notification policy, but cannot be denied the right to use sick leave for authorized purposes. Verification. Employers may require reasonable documentation for absences associated with paid sick and safe time. However, employers can only request verification or documentation after more than 3 days of consecutive use of PSST. No early verification is permitted. Employers' requirements for verification may not result in an unreasonable burden or expense on the employee, and the employee cannot be required to explain the nature of the use. Additionally, employers do not have to request verification. Abuse. If an employer can demonstrate that an employee used PSST for an unauthorized purpose, then that employer can withhold the payment of PSST use. However, the employer cannot deduct those hours from the employee's accrued unused PSST balance. Rate of pay. Employers must pay the same rate as an employee would have earned while working a shift, and this includes shift differentials, commissions for hourly employees. One thing to note, rate of pay does not include overtime compensation, lost tips, or service charges. Increments of use. The increment consistent with the employer's payroll system, not to exceed 1 hour. So if an employer's normal practice is to track increments of work for the purpose of compensation in, let's say, 1-minute increments, then an employer must be allowed to use paid sick leave in 1-minute increments if it's at all feasible for the reason that they need to use it. Cash outs. The law does not require employers to cash out unused PSST balances. The law doesn't prohibit employers from having a policy in place where they can cash out unused PSST balances. However, in this case, partial cash outs are permitted at the end of the year and full cash outs upon separation from employment. And so at the end of the year, employers may cash out PSST balances in excess of the carryover requirement based on the employer's tier size. Upon separation, employers may cash out any portion of PSST balances with mutual agreement in writing. Waiting period. Now, employers may impose a waiting period before any accrued PSST can be used. That waiting period cannot be longer than 90 days. It can be shorter, but it cannot extend beyond 90 days. And so on the 90th day, an employee can use accrued PSST for an authorized reason. Front loading. An employer is permitted but is not required under the law to front load PSST to an employee in advance of accrual. If an employer does front load PSST, then that amount of time front loaded needs to at least meet requirements for accrual, use, and carryover of PSST. Breaks in service. If you have a situation where there's a separation between the employee and employer, and that employee returns back to the place of work, their place of work, within a 12-month period, then they are entitled to pick up where they left off in terms of the number of PSST hours they've accrued, what they've used, and what they have available to use. In situations where you have a separation that extends beyond 12 months, then the employee returning back to their original place of employment would have to start fresh, and they would begin to accrue time as if they were a new employee. Notification. Each time wages are paid, employers are required to provide an employee with information related to PSST available for use, PSST accrued since the last notice, and the number of hours that have been used since the last notice. Employer records. Employers are required to keep employee records for a minimum of 3 years. Those records must include the following items: the number of hours an employee worked in Seattle, the number of PSST hours that were accrued, the number of PSST hours available for use, PSST that was not carried over to the following year, and any situation where there was PSST donated, the employer must have that record on file. Written PSST policy. Employers must provide employees working in Seattle with a written policy that describes how the employer is meeting the requirements of the PSST ordinance. A written policy should cover the following 8 provisions. Employers can distribute a written policy electronically. For additional information and updates, employers can visit the PSST webpage listed on the Seattle Office of Labor Standards website. Access or the link to that webpage is listed on this slide. Employers can also visit the resource webpage of the website. Employers can find the PSST checklist and a PSST policy template on this page. For technical assistance and for ongoing support, employers can contact us directly. This concludes the webinar on Seattle's Paid Sick and Safe Time Ordinance, and I hope you found the information helpful. Thank you for your time and enjoy the rest of your day.